The federal backdoor, the Ray Charles estate, when a perfect plan meets federal law. He called the meeting, he got the signatures, he paid his children, he gave his life's work to charity, and a law passed by Congress in 1976 handed his children a key to the back door of everything he built.
Every episode in the series has been about what went wrong. The unfunded trust, the couch will, the empty box, the deathbed signature. In every case, someone failed to plan. But episode 7 is different. Ray Charles did everything right. He called a meeting with his children. He got signed agreements. He paid them $500,000 each. He left his life work to charity. His plan was perfect. And a law Congress passed in 1976 that Ray Charles almost certainly never read handed his children a backdoor into everything he built. This episode is about the threat that no private contract can stop. Every episode of Estate Interrupted has been about someone who didn't have a plan. Michael Jackson, whose trust existed but was never funded. Aretha Franklin, whose plan was a spiral notebook under a couch cushion. Matthew Perry, who forgot to put his bank accounts in his trust. Shannon Doherty, who waited until the last possible moment to sign. This episode is different. This episode is about a man who did everything right, who thought of everything, who closed every door he could see, and then discovered, too late, that there was a door he never been told about. His name was Ray Charles, and in 2002, 2 years before he died, he called a meeting. Before I go further, I want to tell you something personal. Chris knew this world from the inside. Ron Boyd, who served as Ray Charles's personal assistant for a number of years before joining the Oakland Police Department, was one of Chris's closest friends. And John Burke, who produced Genius Loves Company, Ray Charles's final album, the one that won 8 Grammy Awards, including Album of the Year, was another of Chris's closest friends. The world of Ray Charles was not abstract to us. The music, the legacy, the man himself. This was Chris's world, and that's what makes what happened to everything Ray Charles spent his life building land differently for me than it might for someone who already knows this story from the headlines.
Ray Charles Robinson was blind from the age of 7. He built one of the most extraordinary musical careers in American history, pioneering the fusion of gospel and blues that became soul music, recording Georgia on My Mind, Hit the Road, Jack, and What I Say, I Got a Woman, 60 songs that changed American music. By the time he called his children together in 2002, his catalog was worth tens of millions of dollars, and he had a plan for every dollar of it. Ray Charles gathered 10 of his 12 children. 2 were in jail and could not attend. He sat them down and told them exactly what was going to happen. Each of them would receive an irrevocable trust worth $500,000, plus enough to cover the taxes on that amount. That was their inheritance. That was all of it. The rest of his estate, including the rights to his entire catalog, would go to the Ray Charles Foundation, a charity he built to support the hearing impaired. He asked them to sign written agreements confirming his arrangement, confirming that the $500,000 was their total inheritance and that they would make no further claims on his estate. They signed.
Ray Charles died on June 10th, 2004. His estate went exactly as planned. The foundation received his catalog, his children received their trusts, The estate closed through probate in 2006, 2 years after his death. It appeared to be over. And then 6 years later, 7 of his children walked through that door Ray Charles didn't know existed.
I'm Alexis Nassif.
And I am Natalie Francine. This is Wealth, War, and Real Estate, Estate Interrupted. Episode 7, The Federal Backdoor. For women, by women.
And men too. I always have to say that. I want to explain a law that most people have never heard of because it is one of the most important laws in the country for anyone who creates intellectual property and for anyone who plans to leave intellectual property to their heirs. In 1976, Congress amended the Copyright Act. The amendment included a provision called the termination right. The intent was to protect artists, specifically young artists, who had signed bad deals in the early years of their careers, often giving away their work for almost nothing before they understood its value. Shame.
The provision works like this. Under the Copyright Act of 1976, artists or their heirs have the right to terminate copyright grants, to take back the rights to their work 35 years after the grant was made. For works created before 1978, the timeline is slightly different, 56 years from first publication. The purpose is straightforward. Bob Dylan signs a terrible deal at 22. He gives his early catalog to a publisher for almost nothing. He spends the next 35 years watching other people profit from his genius. And then at 57, the law gives him the right to take it back, to renegotiate from a position of strength. That is what the termination right was designed for.
But here is the part of the termination right that changes everything for estate planning. The right does not belong only to the artist. It belongs to the artist's surviving spouse and children under the Copyright Act. And I want to quote this directly because the precision matters. The artist's surviving children own the author's entire termination interest. That means that even if Ray Charles had left his catalog to charity, even if his children had signed written agreements accepting a different inheritance, the termination right could not be signed away. It is what copyright law calls an inalienable right, meaning no private contract can take it away.
Crazy. The twist, federal law. This is the federal backdoor. The Copyright Act of 1976 created a termination right that belongs to an artist's surviving children by law, regardless of what the artist's will says, regardless of what trust documents specify, and regardless of what private contracts the children signs. Federal law supersedes private contracts. Ray Charles could not give his catalog to charity and simultaneously prevent his children from eventually exercising their statutory right to reclaim that catalog. The two objectives, complete charitable control and complete family exclusion, were legally incompatible, and no attorney in 2002 could have fully resolved that incompatibility because the law itself creates it.
March 2010, 6 years after Ray Charles died, 7 of his 12 children, 4 daughters and 3 sons, filed copyright termination notices on 51 of his most iconic compositions. Georgia on My Mind, I Got a Woman, What I Say, Hit the Road, Jack, A Fool for You, 51 songs under the Copyright Act. They had the legal right to do exactly this, and they knew it. They were represented by Mark Tabaroff, one of the most aggressive intellectual property attorneys in the country, the same attorney who had won termination rights for the original members of the Village People and who was simultaneously pursuing Superman copyrights, terminations from Warner Brothers.
The Ray Charles Foundation, which depended entirely on royalty income from Ray's catalog to fund its charitable work, was facing the potential loss of its entire revenue stream. The children filing those termination notices were not taking money from Ray Charles. They were taking money from the hearing impaired children and disadvantaged youth that Ray Charles had spent his lifetime trying to help. The foundation president said publicly, and I'm paraphrasing here, that the children took their father's money and came back for more. The children's attorney said, the law gives them this right. Both statements were true.
The foundation sued the children in 2012 for breach of contract, claiming the termination notices violated the agreements they had signed in 2002. The children's response was one that every estate planner needs to understand. They said, you cannot contract away a right that federal law calls inalienable. The agreement we signed did not, because legally could not, include a waive of our statutory termination rights. We took the money and the law still gave us the music. Yep.
It's crazy, right?
Yeah.
So I pulled up Luke Perry, you know, Chris's client, because I wanted to see, like, he had no problems with his estate.
My God.
At all. He did everything right. It was 10 million, but
still. January 2013, U.S. District Court Judge Audrey Collins issues her ruling. The foundation argued that the children had breached their 2002 agreements by filing the termination notices. Judge Collins addressed this directly, and her language is in the most important sentence in this entire episode. The Copyright Act prevents the court from the agreement signed by defendants as limiting their statutory termination right. Federal law beats private contracts. The children won. The foundation is ordered to pay the children's attorney fees under California's anti-SLAPP statute. The foundation appealed. The Ninth Circuit Court of Appeals reversed part of the ruling, giving the foundation standing to challenge the termination notices. But the underlying principle was not disturbed. Federal copyright termination rights are inalienable. No private agreement can waive them. That's the law.
the foundation also tried a remarkable legal maneuver. It argued that Ray Charles's songs were works made for hire, meaning they were created under employment to a record label, which would mean the children had no termination rights because the songs never legally belonged to Ray Charles personally in the first place. And then, in an almost extraordinary reversal, the foundation switched positions and argued that the songs were not made for hire, because if they were made for hire, the foundation itself had no standing to challenge the terminations at all. The legal maneuvering was extraordinary, and the outcome was not. The children's terminations rights survived.
Yep, they did. As of 2026, more than 2 decades after Ray Charles died, the battle over his catalog continues. The foundation continues to operate. The children's termination rights continue to create uncertainty over who ultimately controls some of the most iconic compositions in American music history. Georgia on My Mind, Hit the Road Jack, I Got a Woman, songs that defined American culture, caught between a dead man's charitable intentions and a federal law that his estate plan could not override.
The war. The Ray Charles case is not about bad planning. It is about the limits of planning. Even the most sophisticated estate plan cannot override a federal statutory right. The Copyright Act of 1976 created termination rights that belong to an artist's children. Full stop. No trust document, no will, no signed contract can eliminate those rights. What this means for anyone with intellectual property, music, writing, film, software, art, is that federal copyright law must be a part of your estate planning conversation, not as an afterthought, as a primary consideration. This is good for like actors and all those people, musicians who probably don't know.
Yeah, they don't know and they're not collecting their royalties because of that. And that's a tough situation. Some of these artists have gone completely broke and passed away with nothing.
More often than not.
Yeah. Just like the old actors, you know.
Before Alexis walks you through the specific steps, I want to make sure we are clear about who this episode is for, because some listeners will hear Ray Charles and copyright termination rights and think, that is not me. I'm not a famous musician. Intellectual property is broader than music. It includes any original creative works, books, articles, photographs, software code, business processes that have been documented and copyrighted, visual art, film, podcasts. If you have created original work, you own the intellectual property. The Copyright Act of 1976 applies to your estate plan, and the termination right issue applies to everything you intend to leave anyone other than your biological children.
The specific estate planning steps that address the termination rights issue. What are they, Nat?
Step 1. Know what intellectual property you own. This sounds obvious, but most people do not have a complete inventory of their copyrighted works. Your estate attorney needs a full list. Every creation, every copyright registration, every licensing agreement, before they can address the termination rights question.
Step 2. Understand the timeline. Termination rights vest 35 years from the date of the grant for post-1978 works. For pre-1978 works, the timeline is 56 years from the first publication. Your attorney can calculate exactly when your heir's termination windows open and plan accordingly.
Step 3. Build a relationship strategy, not just a legal strategy. Ray Charles's fundamental problem was not legal. It was relational. He gave his children money and asked them to walk away from his legacy. A different conversation, one that included his children in the mission of the foundation, that gave them a meaningful role in preserving his legacy, might have produced a different outcome. The law gave them a weapon. The relationship gave them the motivation to use it.
Yep. Step 4, understand what a buyout strategy looks like. Some states have successfully negotiated with heirs to purchase or structure away the termination right exposure before it becomes a problem. This requires specialized intellectual property and estate planning counsel working together. It is not a standard estate planning conversation. It requires people who understand both bodies of law.
The twist. Federal law. The Ray Charles case has sent a signal through the music and entertainment industry that is still reverberating in 2026. Bob Dylan, Tom Waits, Tom Petty's estate, Billy Joel, Pat Benatar, Journey, all of them or their heirs have filed or are considering termination notices on their early catalogs. The 124 trillion wealth transfer includes an enormous amount of intellectual property. Yep. And every dollar of that intellectual property is subject to the same federal law that Ray Charles's estate plan could not override. If your estate includes intellectual property of any kind, this conversation cannot wait.
No. Every other episode in this series has ended with some version of the same message. If you had planned properly, this would not have happened. This episode ends differently. Ray Charles planned properly by every conventional measure. He did everything an estate planning attorney would have recommended in 2002. He executed documents. He obtained signatures. He structured his charitable bequest. He communicated his intentions directly to his children, and a law he almost certainly did not know about created a right that his children could exercise regardless of everything he did. Yep. They went above and beyond.
The lesson of Ray Charles is not that planning is futile. It is that planning must be comprehensive. It must include the question your attorney has not thought to ask, and the law that exists outside of the borders of conventional estate planning. The Copyright Act of 1976 was passed to protect artists, and it did. It protected Ray Charles's children from an agreement that federal law decided they should not have been able to make. Whether that outcome honors Ray Charles's intention is a question the courts have been wrestling with for more than a decade. What is not a question is this. If you own intellectual property, if you have created something that has value and that you intend to leave someone other than your biological children, you need an estate attorney who understands copyright law. Not just trust law, not just probate law, copyright law, federal law, the law that beats private contracts.
Next week, we go to Hollywood. Stan Lee built Marvel Comics. He created some of the most valuable intellectual property in entertainment history. And in the last years of his life, the people closest to him used the proximity to take $21 million from a man who could no longer protect himself.
The 20-year question for this week. Do you own intellectual property in any form that you intend to leave to someone other than your biological children? And does your estate attorney know about every piece of it and about the federal law that your heirs can use to override your plan regardless of what your trust documents say?
I'm Alexis Nassif. This is Wealth, War, and Real Estate.
I am Natalie Francine. This is Estate Interrupted. See you next week. For women, by women.